Hello friends, Namaskaram. Today I am discussing an important update concerning bail. As we know that we need a bail because we are arrested in a criminal case. But today I am discussing the topic from the angle of section 7 of PC Act. As we know that when we got trapped in section 7 of PC Act and arrested on a spot, in that scenario, it is a priority of our loved one to get bail of us on priority basis. They used to communicate with the council and entirely insisted that we need bail on any cost. But think twice before making such plea. Whether by making such plea you may get bail, you will definitely get the answer in negative. You have to make the proper brief, have to discuss it with the concerned advocate or counsel so that you could submit your bail plea in the proper way. But first of all, we have to emphasize why there's a need of bail. As I told you earlier, because you got arrested and that's why there's a need of bail. So basically we have to emphasize on the principle or the basis, that is the arrest. As far as arrest is concerned, the provision regarding the same is incorporated in section 35 subclause 1 of BNSS that says the police official may, without the order of the magistrate, please be noted, without the warrant of the magistrate, may arrest a person who in his presence committed a cognizable offense. That is very important point to be noted. In non-cognizable offense, the concerned accused could not be arrested because in those cases the permission or order of the magistrate is signed qua non. And apart from that, section 35 subclause 1 subclause B entirely incorporates multiple grounds to justify the arrest. Point number A, to prevent such person from committing any further offense. You are trapped by the concerned ACB or vigilance CBI. Do you think that after having a trap, there is a possibility to commit any further offense? So clause number A is negative. Then the primary question arises, why they arrest? Clause number B, for the proper investigation of the offense. But the key point is that up to the stage of trap, the investigation is about to be completed. Because now certain formalities are pending. For example, recording of statement of the complainant and other witnesses as per the protocol of section 180 of BNSS. And there might be recording of a statement of complainant as per the protocol of section 183 of BNSS. And apart from that, the proceeding might be pending for FSL examination report, sanction order, and proceedings alike. So in that scenario, it could not be said that for the proper investigation of the case, the arrest of the accused is required. So point number B is also in favor of accused. Now we are coming on point number C. It says to prevent such person from causing the evidence to disappear or tampering with such evidence in any manner. So in clause number C, there are two ways by the virtue of which the arrest could be termed as justified. Number one, the accused is going to cause the evidence to disappear, or accused is going to tamper the evidences. But in your case, just think, after having the trap, you are in the custody or confinement of the ACB or vigilance or CBI. In that scenario, there is no possibility regarding the disappearance or tampering of the evidence. So point number C is also in your favor. Now I am coming on point number D. To prevent such person from making any inducement, threat or promise to any person acquainted with the fact of the case with intention to disable him from disclosing such facts to the court or to the police. But already when you are in the custody, there is no question of any threat or promise or inducement to any person acquainted with the facts of the case. And basically what they have collected during the course of investigation is corroborated by the witnesses as per the protocol of section 180 of BNSS. And last but not least, the presence of the accused is required in the court of law. The said step is sine qua non to parry the chance to flee away from courts of justice. Just think in your case whether all the grounds are satisfied or not. If not, then incorporate all this point in your petition. I want to clarify that Honorable Supreme Court in Caton of Judgment specified that the power of arrest is one thing and its exercise should be justified with supporting evidences. The purpose of arrest must not be to cause any person to face panic because it's inter alia going to affect the life and liberty of the person, and which are the part and parcel of Article 21 of Constitution of India. As we know that reputation of a person matters. If a person is arrested without any basis, even in the illegal manner, in that scenario, the esteemed image deteriorated in consequence of arrest could not be resumed to the position in which it was when the arrest was occasioned or witnessed. Please be noted. Apart from that, the judgment of Honorable Allahabad High Court is quite important on this subject. Judgment is Mata Prasad versus State of UP. Judgment date is 12th of August 2025. It is pronounced by Honorable Allahabad High Court. In that case, accused was trapped and finally booked under Section 7 of PC Act. In the present case at hand, there was a FIR against 3 persons. The prime attack of the defense is that there is no demand, even acceptance recovery on the part of accused applicant. Number 2, the co-accused is already inclined on bail, and that's why on rule of parity, applicant deserves the plea of bail. But I want to clarify that to apply a rule of parity, it is sank one on that your role must be on the equivalent or must be on the lesser side. Otherwise, you would not be in a beneficial position. Number 3, the accused is innocent and falsely implicated. I think that it is a famous dialogue of defense. Accused is innocent and falsely implicated. And the dialogue is based on the common prudence that is given to us by law. The law says every accused shall be deemed to be innocent unless proven guilty. So what they are doing is lawful and totally acceptable by the virtue of that doctrine. Apart from that, he submitted that he is not having any criminal antecedent, he is having no active role in the alleged crime, and apart from that, there is nothing on the record to justify detention for the infinite time. The court inclined the bail plea in favor of accused, but the key point is that while giving the benefit of bail, certain conditions are imposed. What are the conditions? You will not leave India. You will not tamper with the witnesses. You will not cause the evidence to disappear. And apart from that, all conditions are imposed which are incorporated under Section 480 subclause 3 of BNSS. So we could say that Section 480 subclause 3 of BNSS is equivalent with Section 35 subclause 1 subclause B of BNSS. So whenever you are having such trouble and your concerned father, mother or loved one is in jail, then you may draft the bail plea in the light of said judgment so that you could enhance the chance to get the bail. I want to clarify that do not be in the anxiety while moving the bail plea. If the amount is huge, in that scenario, you have to wait till filing of charge sheet. Because after filing of charge sheet in such matter, the chance to get bail is on dominant side. And apart from that, we have to rely on the basic judgment of Honorable Supreme Court that says bail is rule and jail is exception. So we have to emphasize on all this point to move the better bail application. So I think that I am totally able to cause all of you to understand the basis of drafting the bail plea in a very simple and systematic manner. And apart from that, you have to read the FIR and have to find out the exact role of you so that you may make each and every chance on dominant side. See you in the next video. Till then, Jai Hind, Jai Bharat.